Hey everyone, it's Lawrence Mack here, real estate broker out of Mississauga and Toronto and founder of Real Estate Rookies. And I'm here again with Bita Di Lisi from Stonegate Legal Services. How are you doing, Bita?
Hi, good morning, Lawrence. Good. How are you doing?
I'm doing amazing. So last session we were talking about selling a tenant property. And today I thought we would just talk about getting back to the basics about landlord and tenant matters.
So, good morning, everyone. It's Bita Di Lisi here. Thank you so much for taking time out of your Monday morning. Today, we're going to be talking about back to basics, what all realtors need to know about landlord and tenancy matters. Most of you know me already. I won't bore you with the introduction about myself, but if you already haven't done so, head over to our social media, like us, follow us on Facebook and Instagram. I always tend to give updates and post videos with what's happening in the realm of landlords and tenants. If you have a smartphone, you can scan the QR code located at the bottom left of your screen and add us in as an automatic contact to your contact list. If you ever require any clarity on any issues or matters landlord and tenant related, feel free to send me an email. I'm most responsive quicker via email because I can respond at any time. If you call our office, one of my powerhouse paralegals will definitely be able to answer your questions. So let's get started. Next slide, Lawrence. Excellent. I won't bore you about myself. Many of you know me already. My background lies in real estate and property management, and all my firm does is provide support to realtors and landlords and investors throughout the province of Ontario. So for this presentation, everything we discuss is for information only. Nothing is to be taken as legal advice. If I can ask that you hold all questions to the very end, and we can do a Q&A. Next slide. Let's get started, everyone. So because our firm provides support to realtors throughout the province, many realtors are not very informed about what they can ask prospective tenants when they're advertising a property for lease. So here are the top 8 questions that realtors can ask prospects when advertising a property for lease. Number 1, what is your income? Number 2, if you work and where you work. Guys, income and employment, they're 2 different things. Employment is a source of income. We don't want to say, you know, Mr. and Mrs. Tenant, if you're not working, you can't move into this property. We can't withhold housing because someone is not working. So we want to find out what is their income. If their income is employment income, we want to know if they work and where they work. Okay. Number 3, how many people will be occupying the rental unit? Are there any pets? Guys, this is the time to ask about pets. I know that, you know, the law says that you can't discriminate or withhold housing from anyone if they have a pet, even if they agree that they won't have a pet at the start of the tenancy. Well, if you want to know whether or not that prospective tenant has a pet, now is the time to ask. Are they a smoker or non-smoker? Permission for a credit check, references from their previous landlords, credit report. I highly recommend the Equifax. I get a lot of agents asking me, do you have a preference about the credit report? And I say, yes, I do. I prefer Equifax. That's what mortgage brokers use when they are qualifying prospective buyers for mortgage. They use Equifax or TransUnion. So I prefer to use that. Other apps that allow you to pull up somebody's credit are not often accurate. Okay, so I'll leave it at that. So here are the top 8 questions that realtors can ask prospective tenants when advertising a property for lease. Let's move on, Lawrence. Now, let's talk about what realtors cannot ask when advertising a property for lease on the MLS. Number 1, if they are pregnant or if they have children. If they plan on having children or they plan on having more children. If they are married, single, divorced, what is their marital status? What is their religion or ethnic background, sexual orientation? If they are on welfare, Ontario Works, Ontario Disability, or any form of public assistance. Do they have a disability? What is their age? I get a lot of phone calls about their citizenship status. Are they a Canadian citizen? Now, guys, the reason why I say stay away from all these questions is because none of these questions are relevant to the tenancy. What does it matter whether or not they're a citizen? What does it matter if they're married or single or divorced? What does that have to do with the tenancy? So if a realtor asks any of these questions, or better yet, if a landlord or an agent withhold housing and won't rent to a prospective tenant because of the answers, this could be grounds for discrimination and a human rights violation. And more importantly, the brokerage and salesperson can be found liable. So guys, please stay away from these questions. Let's move on, Lawrence. So this is a preliminary slide that I included in all my presentations, because I cannot stress how many agents or landlords or even people who are investors don't know how a tenancy can be terminated. Okay, so these are the top 3 questions that I get from my agents. Hey, Bita, can we evict a tenant to sell a property? Or the tenant isn't allowing for showings. Can we kick them out? Or the landlord's lease is coming to an end. Can we give the tenant notice to move out? Next slide, Lawrence. The answer to all those questions, all 3 questions, is a hard no. Okay, so the reason why it's a no is because tenants have security of tenure. And what that means is that they are entitled to occupy the property after the term of the lease has come to an end. So a typical lease agreement runs for a year. So after the year, the tenancy relationship changes from a fixed term tenancy now to a month-to-month tenancy. Okay, so a tenancy can only be terminated in one of 3 ways. This is very important. Number 1, if the tenant decides to leave and gives notice. Number 2, the landlord and tenant mutually agree to terminate the tenancy. Number 3, the landlord gives notice for a reason permitted under the act. So this is by way of a court or a board order. So 3 reasons to end the tenancy, guys. Number 1, tenant gives notice. Number 2, mutual agreement. Or number 3, by court or board. Next slide. Rent deposits. Guys, remember, this is a back to basics Zoom. So I want you to only know the basics, okay? Don't reinvent the wheel, only know the basics. Let's talk about rent deposits. The landlord can collect a rent deposit from a new tenant on or before the start of a new tenancy. That deposit cannot be for more than 1 month's rent, and it can't be used for anything else except for the last month's rent. Now, if a landlord gives a notice of rent increase, the landlord can ask the tenant to increase the rent deposit by the same amount. So you get a lot of questions and inquiries about rent deposits. What can we ask for a rent deposit? Can we ask for 1 year's upfront? Can we ask for 3 months rent? Can we ask for security deposits? No, the only deposit a landlord can hold is a last month's rent deposit in the amount of 1 month's rent, and only to be applied to the last month of the tenancy. Let's move on. What are illegal deposits? Okay, so we talked about a last month's rent. We talked about how much it should be in. The following deposits are illegal. This means that landlords cannot ask for a tenant to provide these types of deposits, with the exception of a key deposit. Number 1, damage deposits. Key deposits we're going to come back to. Vehicle deposits, utility deposits, pet deposits, repair deposits, light bulb deposits. Let's talk about the key deposit. The key deposit, the landlord can obtain a refundable key deposit. However, that deposit must be only in the amount of the cost of the key. If the key costs $10 to cut at Home Depot, that's what your key deposit should be. The key deposit is only for the key, not the locking mechanism, not the garage door remote, not the fob to the gym or the swimming pool or the exercise room or the party room. A key deposit is only for the cost to replace the front door key. Any other deposit requested other than a last month's rent deposit is an illegal deposit. Let's move on. Rent payment methods and receipts. So I used to make this mistake when I was in real estate and I was doing leases. I always used to say in my Schedule A that the tenant will provide 10 post-dated checks in exchange for the key. Well, the law says that a landlord cannot require the tenant to pay rent by way of a post-dated check, cash, direct deposit, or auto withdrawal. The landlord must provide a receipt for any rent payment, rent deposit, or any other charge upon request by that tenant. The landlord must provide former tenants with a receipt if that former tenant asks for one within 12 months after the date of their move out or after the date of the termination of their tenancy. And the landlord cannot charge a fee for providing a receipt. Moving on. All right, let's talk about the N4 notice to end the tenancy. Notice to terminate tenancy for non-payment of rent. The reason why I have included a copy of the N4 is not to provide you with the information on how to fill it out. It's to provide you with the information that if your landlord calls you and says, hey, Realtor Lawrence, my tenant hasn't paid the rent, what do I do? Then Realtor Lawrence says, well, you'll either call Bita at Stonegate Legal Services or you can serve the notice for non-payment of rent, which is the N4 notice. As realtors, please stay away from serving these notices. Guys, you're not, you don't know what the requirements are. You don't know what the consequences are. You're not insured to provide legal services. So please stay away from that. Your landlord can serve this notice or their legal representative can. This is what the notice looks like. Okay, so if your landlord calls you and says, hey, Realtor Lawrence, my tenant hasn't paid rent, Realtor Lawrence is going to say, well, great, you can call a legal representative or serve the notice for non-payment of rent, which is the N4. Let's move on. Cash for keys. Like, cash for keys is a big thing right now. And the reason why is because as we move on from COVID, there are still a lot of tenants or people that are working from home, schools offering courses online. Things haven't quite gone back to normal. And we're finding that realtors are not able to list and sell a property without any sort of resistance from the tenant. Here's where the cash for keys comes in. Cash for keys is exactly what I call it. We would offer cash to the tenant in exchange for the keys. Cash for keys must be an enticing offer or proposal to end the tenancy. It can be anywhere from $5,000, $10,000, $15,000, $70,000, $100,000, whatever is enticing and agreeable between the parties. A legal representative, not the realtor, a legal representative would facilitate the termination of tenancy directly with that tenant. They would negotiate the terms, they would draft a consent agreement or settlement terms and the notice to end and the agreement to end the tenancy, which is the N11. Remember, the second way to end the tenancy is by mutual agreement, which is the N11. Once the consent agreement or settlement terms and the N11 are signed, these two documents are married to one another because they can be signed together and filed with the board together. Once they're filed with the board will issue an ex parte order, which is just a fancy legal term for an eviction order without a hearing. The timing to facilitate a cash for keys can be anywhere from 30, 60, 90 days, whatever the parties agree. I highly recommend that a cash for keys be done prior to the property being listed on the market for sale. And the reason why is that the seller can do, or the landlord seller can do whatever they want. They can paint it, do the repairs, stage it, give it some curb appeal, give it a facelift, and then the agent will be hired on to list, market, and sell, to do what you guys do best. Okay, and on the flip side, you're not going to have any issues with showing times, any restrictions, any issues with the closing dates. You don't have to worry about all of that. The tenant is gone. Let's move on. So cash for keys. This is the agreement to end the tenancy, the N11, the mutual agreement to end the tenancy. This is what it looks like. I just want you guys to know what it looks like. So this, alongside the consent agreement or terms of settlement, is what forms a cash for keys. Next. So let's talk about the consequences on the N11. The N11 must be completed properly, dated, signed, all the information must be correct. I call the N11 the Incredible Hulk because it is such a powerful agreement. And what I mean by that is that when the parties sign, they're giving up their rights to the tenancy. They're giving up their obligations under the lease. If there are two parties must sign the second page. Any errors will result in the board not issuing the ex parte order. And instead, they will hold a hearing date, which is what we want to avoid. So if the N11 is done incorrectly, guys, you're not going to get the order. Okay, so the ex parte order, just remember, it's a fancy legal term for an eviction order issued by the board without a hearing. Next slide.
Quick question about how long does it take for the hearing date that you've been seeing nowadays?
So on an N11, if the tenant decides to dispute it for whatever reason, if there's an error, if they change their mind, they can put a stay on the order. And to stay the order, the board will hold a hearing. That amount of time will take anywhere from about 3 to 4 months. Just remember, these stay hearings are different than regular hearings. So it won't take as long to get a stay hearing. It'll take 3 or 4 months. Regular hearings can take 4 to 7 months now, not 4 to 6.
Okay, so 4 to 7 months for the regular hearings, but this particular one is, 3 to 4, which still would delay the closing if that was an issue.
You got it. You got it. The consent agreement or settlement terms, it's highly recommended that any cash for keys agreement be in writing and the N11 be accompanied by a consent agreement or terms of settlement, okay? And these documents should be drafted by a legal representative. All terms must be outlined clearly and signed by all parties. Guys, remember, the consent agreement or terms of settlement, they outline the rules of the game, okay? Who does what, when the tenancy is terminated, who holds funds, when are keys submitted, when is the cash submitted to the other side. These are all included in the rules of the game, which is consent or settlement terms, the consent agreement or settlement terms. It must be filed with the board alongside the N11 by way of an L3 application. Okay, the L3 application is it's a short form for landlord's application number 3. Next, let's talk about the N12. So what is the alternative to a cash for keys? If parties don't agree to a cash for keys, what can the agent or landlord do? And the N12 is a notice for the landlord's or purchaser's own use. It's the same notice, it's the same process. It depends only on who's moving in. Guys, please don't serve this notice. I have agents who serve these notices because they think they know what they're doing and they have no idea. This is just a screenshot of what the N12 looks like. Like the agreement of purchase and sale, it's an editable document. However, one tiny error, one small error will get this application dismissed and you're going to have to start the process over again. So if you have a closing date on the table and there's an error, the board doesn't care if the property is sold. The board only cares if the process was followed properly. They will dismiss the application. Your client's going to have to start the process over again. And guess who they're going to point the finger to? You as the agent. So this is what the N12 looks like. Is the alternative to cash for keys, the N12. And just to manage your expectations, when an N12 is served, it informs the tenant that the property is sold and the new purchaser requires possession of the property, okay? The N12 must then be filed with the board. Once it's filed with the board, it will take 4 to 6 months for the board to issue a notice of hearing. Now it's 4 to 7 months. The board will then provide their decision by way of an order, usually 30 to 60 days after the hearing. And if the tenant doesn't leave, provided whether or not the board gives them time, 30, 60 days, who knows, then the landlord is going to have to enforce an eviction by way of filing with the sheriff. And based on the backlog with the sheriff, you're looking at about probably 4 to 8 weeks. So the N12 process in and of itself is at about, I would say, 10 to 11 month process. Okay, so it's the alternative to a cash for keys. You're going to have to amend your closing date, and if the seller provided vacant possession in their agreement of purchase and sale, they could be found that they are actually in breach of contract because they're not able to provide vacant possession. And therefore, they're going to end up paying a penalty to the buyer until they're able to provide vacant possession or until the board holds a hearing. Next slide. Does the tenant have to move out? So I have agents who call me all the time and say, well, Bita, we'll just serve the N12. My client doesn't want to pay extra compensation to the tenant. We'll just serve the N12. And I say, well, realtor, have you read the N12? And unfortunately, 9 out of 10 times they say no. And I say, well, I'm going to focus your attention on page 2 of the N12, the second page of the N12. That's a screenshot of the second page. If you can look at the third bolded box from the left down, it says, what if you disagree with the notice? And to the right of it, it says, you do not have to move out if you disagree with what the landlord has put in this notice. If the tenant wishes to dispute this notice, guys, they are not obligated to move out of the rental unit. They can remain in the unit until a hearing date is held. Okay, remember, the agreement of purchase and sale is not relevant to the tenancy. The tenant does not owe a duty of care to the buyer, right? Only the seller does. So therefore, only the board can end the tenancy. If the tenant decides to leave earlier, however, than the termination date on the N12, then the landlord must provide a refund of any extra monies, rent, or deposits in their possession, as well as the 1 month's rent deposit. And guys, this is why I say, please, guys, please stay away from serving these documents. You don't know the requirements or consequences. Next. Let's talk about clauses. I always have my agents who call me and they say, can you have a look at this clause? How do you interpret this clause? I always tell my agents, guys, please don't draft your own clauses. Please don't draft your own clauses, because depending on how that clause is interpreted, it can go from good to bad really quick. And I'll tell you why. I had an agent insert this clause exactly as it is in red, okay? The tenant has the right, if in good standing, to automatically renew the lease term in perpetuity. So one way to view this clause is the tenant has the right, if they pay the rent, if they maintain the property, to automatically renew the lease term. What's wrong with that? Well, if a property is sold or if the landlord wants to move in, the tenant can actually dispute the termination of tenancy notice at the board, because their legal representative can view this clause as the tenant has the right, if in good standing, to automatically renew the lease term in perpetuity. So this clause, when inserted by the agent or the realtor, can prevent the landlord from actually ever evicting a tenant, because it's putting the onus on the tenant to end the tenancy. Okay, so the tenant can dispute the N12 and actually win at the board. There is case law to prevent an eviction, even if the property is sold and the purchaser requires possession. So guys, please stay away from drafting your own clauses. In your leases, use the Ontario Standard Lease Agreement, because all the clauses that you need are actually found in that lease agreement. They're standard clauses. Next slide. Let's talk about service. One thing I love about the real estate industry is that they've really evolved with technology. And what I mean is that you're using your phones to scan and send legal documents. You're using e-signature tools to purchase million-dollar properties. You don't even have to be in the country to buy these million-dollar properties. Okay, I remember in real estate, when I was in real estate, everything was via fax. That was the only method of service of documents. Sending the documents to the cooperating broker, sending it to the listing agent, sending it to the lawyers, everything was by fax. However, the wheels of justice spin very slowly. And what that means is that landlords must serve their tenants in accordance to the rules of procedure of the board in the following ways: handing the document to the tenant, handing it to another adult in the rental unit, placing it in the tenant's mailbox or where mail is usually delivered, sliding the document under the door or through a mail slot. My favorite, fax, by courier, registered mail, or express post. Now, what I always say is, realtors, guys, please don't serve legal documents. You don't know what the requirements are to these documents. One of the requirements that you have to make note about is that if you're serving a document via mail, registered mail, express post, you must add additional days to the date of termination. If you miss that, your application or notice will get dismissed and you're going to have to start the process over again. And you don't want to disappoint your clients because time is of the essence here, depending on what they've done with the property. So please stay away from serving legal documents. Next slide. All right, we're coming close to the end of the presentation. I never charge for any of my giveaways. I'm always giving away my materials. Head over to landlordmastery.ca, download your free copy of the Landlord Mastery Guide. This guide gives you access to a Google Drive. You can find the Ontario Standard Lease, the updated version on it, scripts, forms, other agreements, notice of entry. It's a good, useful tool that you can use in your business, or you can forward it to your clients and they can use it in theirs. Next slide. All right, we've come to the end of the presentation. I would love to open up the floor to a Q&A. Thank you so much for your patience.
Thank you so much, Bita. I've got a few questions before we accumulate the other questions from everyone else. So if you're trying to buy a property and it's tenanted, so by default, the buyer just doesn't care. Like they just assume it's vacant property, and then the seller's problem. Is that like the default?
That depends. Okay, so let's talk about that. The buyer has two choices. They can either assume the tenancy, or they can close on the property and then serve notice, or they can do cash for keys, or they can put it in the seller's court and they can do cash for keys. So depending